Well, thank you very much, Elizabeth. Gerhardt Law would not be what it is without her. She actually gave me the idea to start this, and it has worked out really well. I also want to take the opportunity to do a shout out to the EDC, who were there from the beginning for me, which over 11 years, and they introduced us to the entrepreneurial community in New Jersey and really sort of helped us get started. They introduced us to people who eventually became clients and who are still clients today. So we owe you a big time, and thank you very much for your support. It's a good example of what I think they're trying to do for the entrepreneur community in New Jersey. Also, just want to do a quick shout out to the Gerhardt Law team. Yay, thanks for coming. David, James, Anthony, Christina, Elizabeth, and Wacy, thanks for your help here today. There's the presentation. I'm the only one who has slides today, so I've only got 762, so I think he said 20 minutes is the attention span, so I'm shooting for 15. So we're here to talk about global intellectual property, so why not talk about global intellectual property, right? This is an infographic from the esteemed World Intellectual Property Organization, and it's titled, Who Filed the Most PCT Applications in 2016? So the World Intellectual Property Organization, in case you've forgotten, administers the treaty for the international filing regime. And so while you can't file an international patent application, you can file an application that allows you to file in a lot of different countries. And so these are sort of the closest thing that we have to global applications, and it's an indicator of international filing activity. So just a couple of things to point out. US is down 1% over last year. These are numbers where we're comparing 2015 and 16. Japan is holding steady at 45,000 international patent applications. China, though, and I'm not sure, I've got a laser pointer here. Let's see, there we go. China, note, up 44%. So huge increase in international patent applications from China. So why does that matter to anybody here? Well, if you have a business and you're thinking about filing abroad, and China is a pretty popular place to file international patent applications, the fact that they're filing more patent applications says to all of us that their intellectual property regime is getting stronger. You can't have that many patent applications in a crummy intellectual property system. And so for years, China has sort of been the Wild West in the sense that you file there, you take your products there, their intellectual property theft is rampant, and I think that's going to change. So to the extent that you're thinking about going international, you're thinking about going into China, then that is a good sign for you. And another interesting statistic here is with the UK, not UK, England, but their applications are going up as well. Whether there's any connection between the Brexit activity and the increase, I don't know that anybody could really say one way or another, but I do think that that is something worth monitoring. So I'll take questions at the end if that's okay with you. So the World Intellectual Property Organization also monitors a system called the Madrid Protocol, which basically allows global filing of trademark applications. And as you can see, US is #1 again, but the trademark applications are up about 14%. So patents protect technology, trademarks protect brands. So Coca-Cola is a typical type of trademark. And so the overall activity in trademark applications has gone up. China, 68% increase in trademark applications being filed. And UK has also been going up 10%. So, so these are just sort of to kind of set the stage for today's discussions. To kind of change just a little bit, I put a history of famous inventions here, a short history of global innovation. Paper currency was invented by the Chinese in the 7th century, printing press about the 1400s in Germany, postage stamps, England, steamboat, comic strips, vacuum cleaners, parking meters in 1935. I assume that they invented parking tickets also in 1935. And then we have CD-ROMs in Japan. So the point of this slide is to say that global innovation has been with us since the beginning of human history, right? We've had innovations that have crossed borders, and despite sort of the current political climate, I believe that even with the talk of nationalism, that global innovations are going to be continue to be shared between countries, right? So global innovation is not going away, and global intellectual property is also going to be an important factor in businesses going forward. So this is for our friends from Cuba. Intellectual property, of course, isn't just patents and trademarks, but it's also artistic expressions, music, all of the types of things that people create. And this happens to be from Armando Merino, who's a favorite Cuban artist of mine. It's kind of a neat invention. There's probably some symbolism in there someplace. But I thought to honor the day, I'd let you feast on this for a second. So the top line or the bottom line is that world demand for IP is going to continue to grow. Total applications, patents up 2.9 million. Utility models, which is another type of patent applications, are up. Trademarks worldwide up 8.5 million applications. And industrial designs or design patents are also increasing. So any questions about any of the things that I just discussed? Yes, sir.
You didn't put India down there. Is India a big patent place?
Yeah, India continues also to grow, not at the rate of some of the other countries, but there's a substantial presence of intellectual property in India as well. So these are the top countries. I'm not exactly sure where India falls on the spectrum, but yes.
Richard, what do you attribute the much larger percentage of U.S. patent and trademark applications versus the rest of the world?
The rest of the world. Well, we could say we're more litigious, but I don't think that would be the right answer. The right answer is that we have a lot of innovation, and so there are people who spend their lives studying intellectual property statistics. I mean, I think if you think doing patents is requires a lot of concentration, people study these things, and there's a lot of correlation between innovation and intellectual property filings. And so to a large extent, I think that the U.S. has in addition, the U.S. has a very strong patent system and trademark system, compared to other countries in the world. And so, or at least that's the perception, well-developed legal rules. And so the patents and trademarks here have comparatively a lot of value compared to other places. So some other countries, Mexico, the judge probably hasn't seen too many patent applications, doesn't even know what one is. Here the courts are very familiar with them. So, yes, ma'am.
You mentioned a website for searching global patents. Would you mind repeating that?
Sure. Probably the one that what you would be thinking about is the World Intellectual Property Patent Scope website. And so if you just type in WIPO.com, you'll find your way to it. And you can actually do searches on PCT applications. If you're doing a technology search, though, you need to look at some other databases as well, because the World Intellectual Property database doesn't necessarily capture every single application. So if it's not filed as a PCT application, it won't be there. So, all right, well, let me keep going here. And now for something completely different. I did talk about a little bit about innovation and inventorship. I think this is, let's see. So we're going to talk a little bit about collaborative patents. So what are collaborative patents? They're patents where you have one US inventor and one non-US inventor. So in other words, you have an inventor in the United States, and then you have an inventor in another country, such as Cuba or England or Canada. And these types of patents with these collaborative inventorship arrangements now represent 26% of the patent applications filed at the United States Patent and Trademark Office. So 1/4 of our patents now are global. This is an increase from about 4% in 2004. So it's been going up about 20% per year. So again, as an entrepreneur, why would you care about this? Well, there are certain things that you need to know if you find yourself in the situation where you have collaborative patents, that is, an inventor in the US and then an inventor outside the US. And some of this I'm going to go through may seem a little technical, but the most important thing is to make sure that you talk about it with your patent professional if you're in this situation. So, so where do the collaborative efforts actually come from? Well, the most typical is where you have cross-border research teams. So that's a lot of multinational companies are doing that. They're doing research in multiple countries. They do this for a lot of reasons. One, they want to get to know the local market, the local culture. So they do a research project with somebody in a foreign country so that they can understand the markets better. But there's also lots of services that many of you may have used, such as Upwork, Fiverr. Lots of times these contractors are actually located in different countries. And so if you're using these types of people and they're making inventive contributions to your intellectual property, you need to be aware of some of the rules that we're talking about. Software developers, it's almost the norm now for people to be working overseas cross-border arrangements with software developers. And prototypers and manufacturers as well. Lots of times the product, the consumer product, is prototyped in the country by the factory that's going to be making the product. So again, lots of times inventive contributions are made under these circumstances. So these are just a few relatively practical, I think, scenarios that could arise where you may have inventive contributions from somebody outside the United States. So what are the implications of these things, these arrangements? And I don't really think that the legal profession is really catching up with this because it's sort of crept up on us over time. But part of it is you need to understand information exchange requirements in order to avoid violating export rules. So typically these rules only apply to sensitive technology, nuclear technology, weapons manufacture, but there's also a lot of technologies that can be used for dual use. And software encryption technology, for example, is one area where that is coming more and more under the BIS regulatory regime. So if you do have technologies that involve export rules, and this is a very, very complicated area, but you need to at least create an awareness, and you need to talk with somebody about just to make sure everything that you're doing is proper. Violating these rules can have serious consequences. People go to prison. They're fined. If you go to the BIS website, the government makes a point of putting prosecutions on the website of companies that they've targeted or that they're fining. This could have real serious consequences, and not to mention it could be a real problem for your patents as well. Foreign nationals who are working on these sensitive technologies, there didn't used to be a lot of concern for that, but now, again, things seem to be shifting a little bit. So please keep these principles in mind as you move forward. And then the patent applications that are filed under these global regimes, there's a whole regime of legal rules where you have to get certain types of licenses to file your intellectual property overseas. So just because the one inventor is in the US doesn't mean that automatically you can file here. We have some countries, for example, France, Russia, Portugal, where it must be filed in that country. If you have a Russian inventor, you have to file in Russia, regardless of where else it was created. In some countries, you can file in another country, but you have to get a license first, so that's the case in the US. So we do this a lot in China. We have an inventor in China, and in the US, we have to get a foreign filing license to file in China first from the US government. And the reason is it takes about 4 months to get a foreign license from China. And then some countries really don't care at all: Japan, Australia, Mexico, Indonesia. So if you don't want to memorize this, you really don't have to. But the point is that there should be some awareness for you as you move forward in these collaborations. Any questions? Yes, sir.
All patents expire, and what about sensitive patents? Would they expire for a certain amount of years?
So sensitive, every technology is reviewed by the US government, every patent application for state secrets. If there is a state secret, then the application is put under a secrecy order, and it's put under a secrecy order for as long as the US government thinks that it is should be kept as a state secret. So then after the secrecy order is lifted, then the application can be prosecuted, can be prosecuted normally. Depending on when the application would be filed depends on when the application would be expired. So when I was at Dow Corning Corporation, I knew an inventor who had application under a secrecy order for 20 years before the government finally released it for some sort of adhesive. But again, I'm sorry, did that answer your question?
Is it 20 years that they expire normally?
Yeah, normally 20 years from the date of filing.
Globally?
And that's the case for every patent regime that I'm aware of, yes. Yes, sir.
China specifically, there's a lot of patent activity, but in terms of the court system, I know, for instance, in India, that trying to get a court date
Is impossible.
to get a patent is takes years.
Right.
What's the situation in China?
Well, I mean, I think it's still pretty much the Wild West, so there's different ways that you can enforce intellectual property in China. One is to go through government agencies, and sometimes you can do that locally. There's also, all of the intellectual property disputes are regulated by, government bureaucrats, and it depends really on what province you're in and what type of action that you want to bring. So I would still characterize the environment there as less than perfect, but by the same token, I do think, I'm optimistic that it'll improve over time. So yes?
Richard, are you going to cover the same thing with trademarks? So suppose you use Fiverr, somebody's produced a logo for you.
Yeah. I'm not really covering trademarks. I'm not sure that would be such an issue under trademark rules, because you're not, it's branding and not technology that's implicated. So I don't know, do we have any Gerhardt Law people who'd want to comment on that? No? Okay. So I must be right, according to them. So, well, no, I'm just going to get in trouble later, right? No, how could you say that? But what's really weird, is that I was told, I don't know if this is really true or not, but I'm going to say it anyway just because it's fun to say. In 20 years, I was told by the head of our UK patent department that France still had export of technology rules on the books from World War II. And as of 1997, if you exported technology from France to another country, you could be executed. So I don't know if, I'm very careful about that. I don't know, if that's still the case or not, but this is what I was told. So he definitely was trying to make a point that we should be very careful with how we handle the technology. So, any other questions, or, yes, ma'am?
Let's say, for example, I'm a sole inventor, and I want to have the invention manufactured in China.
Mm-hmm.
Would you recommend patenting the idea or concept prior to traveling, or would you recommend also patenting the item in China as well, in terms of protecting the proprietary information?
That's a really a great question. I would say at a minimum, you should file a patent first someplace, probably in the United States if that's where the invention was made. Under all the treaties, you have time to file a patent application in China. It would be treated as if it were filed on the same day as the US application. But sometimes some of our inventors accelerate that process and they'll file the Chinese application sooner just because they want to have something on file so whoever they're dealing with can say, oh, I've got a patent here in China too. And so that's, that depends on a lot of factors, but you could do both. So, yeah. So, all right. So almost done, don't worry. So I'm just going to toss out some more doing business internationally types of things. So first of all, if you have two people from two different countries on your patent application, it's automatically considered joint intellectual property, joint meaning you have more than one inventor. And under the US rules, if there's no contract, then there are rules that govern that relationship. So in the US, if you have joint intellectual property, you can commercialize or license the technology without the permission or the accounting to the other party, right? So you don't have to pay them any of your profits unless you have an agreement. You can go ahead and do whatever you want to. You can dispose of your share however you want to. Lots of countries have different rules on this, right? So you could have the same joint patent in China. In that case, you have to pay the Chinese inventor part of part of your funds. So the point is that you can alter these rules by contract. So if you have one contract that says whatever you want, we're not going to commercialize this without the permission of the other person. Anybody who commercializes pays the other person some percentage. You can do that in every country in the world, right? But if you don't do anything, then it's whatever the local jurisdiction discusses. So again, that's something you want to be aware of. You want to make sure that those things are nailed down early in the process. If you're working with an Upwork person or a Fiverr person, a software company, make sure that you get the formalities done. And then, of course, our favorite, always get a confidentiality agreement before you disclose technology. So either you file your application earlier, and then this becomes less of a concern, or if you're still discussing and sharing, make sure that you get confidentiality agreements. So that protects a lot of your legal rights. And finally, make sure formalities are worked out early, assignments, contracts, etc. So going a little bit further now, this is our Cuban flag, setting the stage for our discussions today. Where Cuban population, as of 2015, was 11.39, ranks number 76 in the countries of population. Gross domestic product was around 2.26 billion, ranked number 56. Both Cuba and Cuba's a member of the PCT and the Madrid Protocol. And the Cuban patent filings, why not? Actually pretty active for a smaller country. You can see that the general trend of filings has been going up. The resident filings there, which are the brown ones, are ones that are filed by residents of Cuba. Non-residents, which would be foreigners, are in the orange. So those have been generally going up. And then Cuban applications filed abroad are reflected in the aqua here. And these are inventors that have from Cuba that have filed applications outside of Cuba. So pretty good activity. Fields of technology in Cuba are really heavy on the life sciences, pharmaceuticals, biotechnology, and then much less really in the other sectors, which would be, electronic, medical technology. Really, Cuba sort of has a reputation for having a strong health system, so this, I guess, makes sense. And then now we have England, population of roughly 65 million, gross domestic product of approximately 2.5 trillion, also member of PCT and Madrid treaties. And these are the filing activity, pretty constant in terms of non-resident, also fairly constant in terms of resident, and applications filed from the UK abroad has been trending upwards over the last 10 years or so. So, and technology, really just a really wide variety of technologies. I don't know what the others are, but really a wide variety of technologies as well. So, so that's all I got. So thank you very, does anybody have any questions before we move on to our first panel? Yes, sir.
To what extent can you hold secure text or drawings in the patent to prevent re-engineering?
Well, that's a good question. So the idea of a patent, the sort of the policy behind patents is to you disclose your invention in return for a monopoly, right? So that's what the patent system was designed to encourage. And so you get this exclusivity if you tell everybody what you're doing, right? So, so it's really kind of difficult to do that. One option would be if you only limit your filing in the United States, you can keep your application as a trade secret for as long as it's pending at the patent office. But then eventually the patent would, publish, and then, the information that's in the application would become available. There is still sort of a best mode requirement, which requires that you disclose your best mode. It's a patent office requirement, however. It's not generally now after the AIA enforced in courts. And so, you might want to come up with some strategic ways to make that information maybe less accessible. So there are options, along those lines, but in general, you're going to have to tell the patent office in the world what your invention is. And if you would rather keep it as a trade secret, then maybe it makes more sense not to file a patent application.
As a follow-up question, the patent doesn't protect what you're doing for research purposes, is that correct?
Well, in some technology areas like life sciences, there's a safe harbor for research where you can't file a lawsuit for using, doing research for, called research tool patents. But that's in the life sciences arena. So outside of that, any use technically could be a violation of a patent. But then it comes down to, well, is it worth filing a lawsuit? What are the damages? How do you find out that they're infringing the patent? So there's a lot of practical, practical considerations and that kind of thing. Yeah.
And that's a question, right? It's one thing if you're a big corporation and you have lots of resources, but if you're a small company, which is kind of what this is about,
right?
You file a patent and now you get some big competitor, whether here or overseas, that's sort of infringing on one or more. It could be prohibitively expensive, right, to actually litigate that. So what are the options in that?
Well, so that's a great question, and there's a couple of different ways to look at it. First of all, lots of times patents will keep people out of a technology area, and you'll never even know it, because somebody will come to us and say, we want to put this product in the market, and we'll say, there's another patent on there, so don't even go there. So sometimes or you say, you're going to have to design around this patent. And so it may take them 6 months or a year to design around that patent, but you as the patent holder don't even know that, right? I mean, we run across this every day. We do, 30 or 40 patent searches every month, right? So you don't really know what's going on. But let's just say that somebody does start infringing your patent. Yeah, it gives you something it only gives you something to fight with. It can be a resource-intensive activity. Depending on the amounts involved and the size of the market, there is venture funding. I know, VCs who will fund patent lawsuits if they think that there's, a big enough pot of gold at Rainbow. Some companies are very unethical and they're just going to run right over any other patents, but sometimes, the management is like, well, if we want people to respect our patents, maybe we should respect other people's patents. So there's it's a business tool. It's not always perfect, but sometimes it works out really well. So I don't know if that answers your question. But to your point, international patents, you got to know somebody is infringing it. So if you're in China, how are you going to find out about that? Lots of times the salespeople will be out there, or they'll say, this other product is on the market. I thought you guys had a patent on this. Or, your customer will say, I got approached by this person, they're offering us this product, and I want you to reduce the price, and you're like, wait a minute, we got a patent on this, why is somebody else out in the marketplace? So that's kind of how people find out about it most often. So, yes, sir.
In the country you mentioned, China, where they have to pay the inventor a fee, is that a statutory fee if there's no other contract, or how does that work?
Oh, I'm sorry, I didn't understand your question.
Is it a statutory rate set by China, the rate that the licensee has to pay to the Chinese patent holder if it's not specified in the contract?
No. So it's just a fair, from what I understand, when I last read the statute, it was like some sort of fair apportionment. So it's not necessarily 50-50. So.
And then my other question, and this is maybe a basic question, but when you say somebody's filed for a patent, is that automatically, obviously they're not automatically getting a patent, but what percentage don't get a patent or get orphaned or?
Well, in the United States, I don't really know about other, but 45% of patents filed mature into granted patents. So that is now, I'm happy to say that our percentage at Gerhardt Law is significantly higher than that. But that's the average.
Is that similar for trademarks?
I don't have any stats on trademarks. I wouldn't even guess, but I will find out. I would like to know the answer to that question myself.